Greetings and welcome back to my YouTube channel. My name is Bulali, and today we're going to talk about an aspect of the law that's likely to affect all of us at some point in time, the law of damages. Now, what is the law of damages? In a nutshell, the law of damages is where you cause some kind of harm to another person for which they can hold you legally liable, they can sue you, and you have to pay them compensation for whatever damages they may have suffered. So the most common and simple case of damages is what they call slip and fall. Now, if you own an establishment or and you walk around a shopping mall, you always see when they're mopping there, they'll have all these signs, wet floor, wet floor. That is to protect them from a slip and fall case. Because if you walk on a wet floor and you fall, slip, fall, break your wrist, that mall or whatever public place it is liable for your damages. Now, the law of damages is based on causation. There must be a proof that there's a link between what the wrongdoer did wrong and the damage you suffered. So it must be proven that the mall's wet floor caused you to fall and break your wrist, and therefore the mall is liable for that damage. Damages are also split into categories. There's your your measurable damages, which is your medical bills, etc., and your general damages, which is what is not really quantifiable in numbers, but your pain and suffering, your inconvenience, all the nonsense that comes with breaking an arm. So that mall would be liable to pay you for those damages. But now, back to causation. Causation itself is split into two categories. There's factual causation and there's legal causation. You're only liable for legal causation, what the damage caused by legal causation. Factual causation is a broad test and a simple test. Factual causation is basically, were your floor not to have been wet, would the person have fallen? Would the person have broken their wrist? Would they have suffered that damage? But legal causation is more narrow because legal causation says you are only liable legally for the consequences that flow directly from your actions. And the reason that separation exists is because what often happens, and I'll tell you an actual case I came across. A lady was in a public pool, slipped, fell because the pool had some algae or whatever. The pool floor was slippery. So she slipped, fell, broke her wrist. Goes to hospital, gets treated, gets discharged, goes home, and while at home, somewhere in the process of caring for her wound goes septic, and she then needs a whole nother operation, and the damage is multiplied. Now, back to the owner of the pool, which was a municipality. Is the municipality liable for all of that damage? And the answer is no, because you are only factually, yes, factual causation. Had that pool not been so slippery and dirty, that person wouldn't have fallen, wouldn't have broken their wrist, wouldn't have had that wound wouldn't have gone septic. But you can see now the chain of events is getting a bit long. So legal causation comes back and says, listen, you're only legally liable for the reasonable damages that flow directly from your negligent act, which is having a slippery pool open to the public. So what is going to break this chain of events? The slipping, the falling, the broken arm, the hospitalization, the discharge, whatever happened at home, and the septic wound. And there's a Latin term for that. It is called a novus actus intervenes, which basically means there must be a new intervening act to limit your legal causation. Now, in this case, the new intervening act is either something negligent that the hospital did, which caused the wound to go septic, or something in the wound dressing and wound care while the patient was at home that caused the wound to go septic. So we go back to factual causation. The person fell, your pool was dirty, the person fell, and that falling caused all of this sequence of damages. But legal causation says you are only liable for the ordinary costs and ordinary damage that person would have suffered without the new intervening act. Because if you hurt someone a little bit and they go to a hospital and the hospital hurts them 10 times more, you can't legally be held liable for all of that damage. In those cases, that person would have to bring a new case against the hospital. And your liability, legal causation would say you are only liable for the reasonable cost of repairing a broken wrist, the plaster and the doctor's fees and all of that. But where that new intervening act being the hospital's negligence or the patient's negligence after being discharged that caused the wound to go septic, you as the owner of the swimming pool are not liable for that. So this is something we are all likely to deal with at some point. It's either we're going to be the person harmed or we are going to own some kind of establishment or negligently cause some kind of harm to someone else. And if you find yourself in that situation, be very careful not to take on the liability for things that you are not you can't be linked to your act in terms of legal causation rather than factual causation. I hope you found that helpful. Thank you very much for watching. Feel free to like, comment, subscribe. Thanks very much. Cheers.